For what purpose does the gentleman from Kentucky seek recognition?
Mr. Speaker, I ask unanimous consent to address the House for 1 minute.
Without objection, the gentleman is recognized for 1 minute.
Last month, we ended the vaccine mandate for the military, but there's still many unscientific, illogical, unconstitutional mandates for vaccines in this country. If you watched C-SPAN last week, you saw 434 of us in here screaming, yelling, cheering, speaking, many of us unvaccinated. Most of us probably not boosted. So why do we have a double standard? Why do we make visitors to this country get vaccinated just to come visit their friends and family? Why are we separating families over this? We need to end that mandate. We need to end the health care mandate. We need to end all of the mandates, and we need to do this now. I yield back.
For what purpose does the gentleman from Texas seek recognition?
Nice.
Madam Speaker, I rise in support of this rule and in support of the underlying legislation, H.R. 140, which went through regular order, which was marked up in the Oversight Committee, where Democrats had copious opportunities to offer amendments and to change the bill, as did Republicans. H.R. 140 is called the Protecting Speech from Government Interference Act, and it would prohibit federal employees from using their official authority to censor a private entity, including outside of normal duty hours or away from an employee's normal duty post. Under President Biden, administration officials and federal bureaucrats have abused their positions, authority, and influence to encourage censorship and erode Americans' First Amendment rights. Recently released reports have uncovered efforts by the Federal Bureau of Investigation, the Centers for Disease Control, the Department of Homeland Security, and other government agencies to pressure social media companies and internet providers to censor and remove speech posted on social media platforms. Advocates for this censorship flagged certain posts and users as spreading misinformation on various topics, including COVID-19, racial justice, and the U.S. withdrawal from Afghanistan. Executives at Facebook and Twitter have admitted that prior to the 2020 presidential election, after warning from the FBI, they censored the sharing of news regarding Hunter Biden's laptop leak, which has since been proven true. It was not a Russian disinformation campaign. Even former White House Press Secretary Jen Psaki, during a July 2021 press briefing, called on Facebook to ban specific accounts from its platform. Congress should recognize that the biggest spreader of misinformation over the last several years, whether it's been about elections or about COVID, has been the federal government. The censorship must stop. Congress must restore constitutional protections enshrined in the First Amendment. H.R. 140 and the amendments that are pending votes here as well are critical to ensure that government officials can never again promote censorship and pressure private entities to suppress Americans' First Amendment rights. Additionally, the rule before us provides for consideration of H.J. Res. 27, a resolution providing for congressional disapproval under Chapter 8 of Title 5 United States Code of the rules submitted by the Department of Army Corps of Engineers, Department of Defense, and the Environmental Protection Agency relating to revised definition of waters of the U.S. It's Groundhog Day again in America. Every time the administration changes, this rule changes. The Biden administration's new rule would radically redefine the term waters of the United States to expand the federal government's authority in regulating bodies of water. Specifically, Biden's EPA would expand the term to include impoundments of jurisdictional waters, tributaries, adjacent wetlands, and additional waters. To be clear, what the Biden administration is pushing through here will heap serious burdens on farmers, small businesses, home builders, and rural communities across our country. In 1972, Congress didn't tell the EPA and the Army Corps of Engineers, do whatever you think is necessary to protect water. That's not what the bill said, yet that's what they've taken as their directive. The Clean Water Act was never intended to be applied as broadly as the Biden administration is proposing. Every member of Congress should be concerned about the EPA's attempt to expand its authority over individuals' private property and regulate farms and communities, even those which lie far away from any lakes, rivers, or streams. and very far away from Washington, D.C. Congress has the constitutional authority and responsibility to provide oversight and to review regulations issued by the executive branch. If the executive branch promulgates rules that could overstep their authority, as President Biden is doing here, it is vital that we exercise our oversight authority in Congress. Finally, the rule before us provides for consideration of Senate 619, the COVID-19 Origin Act of 2023, which would finally declassify any information relating to potential leaks between the Wuhan Institute of Virology and the origin of COVID-19. In 2020, at the height of the pandemic, anyone who spoke out questioning whether COVID-19 might have come from the Wuhan lab in China was denounced as a conspiracy theorist, and their words were labeled as dangerous misinformation. People were censored online, their accounts were suspended, and their reputations were damaged for questioning the origins of COVID-19. What's the difference between COVID-19 conspiracy theory and the truth? About 2 years. We've seen them call natural immunity conspiracy theories. We've seen them call people who said that masks don't work a conspiracy theorists. And now we're finding out that all of those conspiracy theorists, so-called, were accurate. Fast forward to today, even the government admits it. The Department of Energy and the FBI have both publicly reported their conclusions that COVID-19 likely emerged as a result of a lab leak from the Wuhan Institute of Virology, a research institute in Wuhan, China, controlled by the People's Republic of China, and ultimately the Chinese Communist Party. And was it funded in part by our government? Yes, it was. This legislation is long overdue and is necessary to expose the truth about the origins of COVID-19. Americans deserve to see the information. President Biden could have released this information at any point. It could have been released a year ago. It could be released today without this resolution. But this resolution is important because the president has not released this information. The last Congress, led by Speaker Pelosi, could have voted to do what we're doing here today. But no, they wanted it to remain hidden from the American public. I fear the federal government has been involved in a cover-up about the origins of COVID-19 because they are afraid of being exposed as culpable in the creation of the disease at the center of the pandemic. And to my colleague's point about the videos that were released on Monday, I think the other side of the aisle is out of touch and out of step with the American public on this. A recent poll by Rasmussen showed that 81% of likely voters believe that all of the tapes should be released. The Democrats had 2 years to release these tapes, but 81% of voters believe that. Is that just Republicans? No, 86% of Republicans and 78% of Democrats, they're out of step with their own party, believe that these videotapes should be released because Americans deserve to know the truth and the defendants in these trials deserve to have the evidence they need to present their defense. I urge my colleagues to support this rule and reserve the balance of my time.
The gentleman is.
Well, somewhat serendipitous, but in the context of this debate on a rule about other bills, it seems we've come to some agreement, it appears to me, with the American people, 81% of whom believe that all of the tapes should be released. It seems like we've come to some agreement that we'd all be better off if we get to the bottom of the truth and all of the truth comes out and all of the tapes come out so that no one side can distort what actually happened that day, and then let the American people decide. So I will not. The gentleman's time's expired. So Senate, in the interest of transparency and in the interest of getting back to the subject matter at hand, which are 3 bills covered by this rule, I want to talk about Senate Bill 619, which is so important. It's transparency, and it's the transparency that the American people deserve. It passed by unanimous consent in the Senate. Even though it seems like there's some opposition on the other side, I suspect we're going to get a lot of votes from Democrats on Senate Bill 619. And I think it's important to go on the record for people to say whether or not for elected representatives, to say whether or not they believe their constituents are entitled to the truth which our government possesses, or at least information that they possess that would help somebody come to a conclusion on what the origins of this virus were and did they come from Wuhan. So the president could do this at any time. He could have done it at any time in the past 2 years. He hasn't done it. It's time to put him on the spot and say, you either veto this, and I suspect we could overcome his veto, but you either veto this or you release that information that you've withheld from the American public for 2 years, which is too long. Next, I want to talk about the Waters of the U.S. rule. Why is this timely? Because on March 20th, this goes into effect. That's why it is so urgent to repeal the 2023 Waters of the U.S. rule. Was it written? These are laws. Were they written by lawmakers? No. Our founding fathers created 3 branches of government. You've got the executive branch, which enforces laws. You've got the judicial branch, which resolves disputes. And you've got the legislative branch, which is supposed to make the laws. Yet, here we sit abdicating that authority, that responsibility. You could delegate authority. You can't delegate responsibility. We have a responsibility to the American people to make sure that these laws are concise, that they don't change on the whim of an executive who gets in the White House, that they are not onerous, and that they have their intended effect, and that they are applied uniformly across the country. Yet we have abdicated that responsibility, but we will take that responsibility back by the passage of this rule and the subsequent legislation to repeal the Waters of the U.S. 2023 by Joe Biden. The American people deserve that. And finally, I want to close by talking about H.R. 140. This is a bill that went through regular order. What a wonderful thing. We've talked about it so much. It's a bill that covers one topic only. We've talked about that so much. And here we are. And we've even got a chance, even though it was amended in the committee, we've got a chance to amend it here on the floor, to perfect it even more for members, by members who aren't members of that committee. Are these amendments that are not germane? Are these the kind of amendments that the American people hate, where you offer an amendment and you stick something into a bill that's completely unrelated to it? No, every one of these amendments is germane to this bill. We have made sure of that in the Rules Committee. I will not yield. The gentleman's time's expired, and he serves on the Rules Committee, and he had plenty of time to voice his concerns there. So we've got a lot of amendments that are great. I think they'll improve the bill, but what's most important is people have a chance to have their point made and to get a vote on this. So finally, I want to talk about what H.R. 140 would fix. It would fix this loophole that they think they've constructed that allows the federal government to violate the Constitution. Obviously, the federal agents can't take away your First Amendment rights, and obviously, social media companies aren't subject. The Constitution wasn't meant to bind them. It was meant to bind the administration. And what we have is a loophole where the administration leans on a social media company that they are paying money to. Millions of dollars have gone to these social media companies from CDC, from FBI. So when they say, would you pretty please ban this user? Would you pretty please take down these posts or a whole series of these posts? The government doesn't get in line. They've got a back door that they can trot to every day and submit lists of people who they think should be banned because they don't like what they've said. This is dangerous to our republic. If the other side wants to call it a democracy, it's dangerous to the democracy, but this is a republic. Our government has built an elaborate but constitutionally unsound framework for violating these natural rights. As we've seen with the Twitter files, they boldly work in close cooperation with private sector actors who aren't subject to constitutional restrictions imposed on government by our founders. But they also claim foreign influence and national security, so they can target U.S. citizens and with agencies of the government under the military chain of command, whose missions are ostensibly directed at foreign actors who have no constitutional rights. Elected lawmakers be damned. Legions of government lawyers create shaky legal scaffolding and ad hoc doctrine to indemnify the actors within our government who eagerly exploit these loopholes. In this way, government actors can claim everything they do is illegal. They've got a bunch of lawyers to back. Oh, we didn't do anything illegal. It's all legal. Here, look at our doctrine. We've got, the lawyers have gone through it. It's all legal. Here's the problem. Much of what they do is unconstitutional. So whose job is it to resolve that difference? It's actually not the Supreme Court's job. We are entrusted with oversight. We all here swore an oath to the Constitution. And if we know that authorizations that we've made or that funding that we have appropriated has been twisted in a way to get around the Constitution or to drive through a loophole that some lawyers in the administrative branch have created, then it is our obligation. We owe it to the American people. We swore an oath to the Constitution to fix that. Not to make them go to court to get some remedy, but to fix it, to stop it in its tracks. H.R. 140, with its pending amendments, is a good down payment on that promise to the American people. And with that, I support this rule. I urge my colleagues to vote for it. And Madam Speaker, I yield back the balance of my time and move the previous question on the resolution as amended.
From Massachusetts reserves, the gentleman from Kentucky is recognized.
Although it's not the subject of today's resolution or any of the bills covered by this resolution, the Democrats just can't avoid talking about the release of the January 6th videos. They keep going back to it during this debate. I want to remind them that 78% of Democrats out in America support the release of all of these videos. Now, the fact that they're apoplectic about the few minutes of video that Tucker Carlson released on Monday shows that Tucker Carlson is over the target. For 2 years, they've been selectively releasing information and videos to set a narrative. And in just a few minutes, the entire narrative was challenged. I say it collapsed under the scrutiny, under the review of just a few minutes of undoctored video that came from this body. So I applaud Tucker Carlson for releasing that. The American people are right. And the Democrats, if they're so upset that only a few of these videos were released, I would remind them that they were able to release these at any point in the past. Make no mistake, this administration wants to ban gas stoves. They've said it out loud. 38 to 40% of Americans use gas stoves. I asked the ranking member of the Committee of Jurisdiction for these bills to save our gas stoves. Did he have a gas stove? In fact, he does. I asked him, does it meet the new standards? Would he be able to buy one in the market? He has no idea. He was offended that I would ask such a question. But we have two bills here to protect your gas stoves, the Gas Stove Protection and Freedom Act and the Save Our Gas Stoves Act. The Federal Interagency Committee on Indoor Air Quality has never identified gas cooking stoves as contributing to asthma or respiratory illness, nor has the Consumer Product Safety Commission nor the EPA ever identified gas stoves as a significant contributor to adverse air quality or as a health hazard. But the other side of the aisle, they just don't like gas stoves. They're reaching for any reason to ban these things. But they shouldn't. It's short-sighted. Number one, what if everybody had an electric stove? How would they get the energy? Well, you would burn natural gas, as many states do, most states do, in a turbine. You would generate electricity in a process that's hardly 50% efficient. Then you would transmit it over power lines to the household, which could be hundreds of miles, at an efficiency of maybe 70% by the time it goes through all the transformers, get to the house, and then heat up the pot. Why not take the natural gas to the house and burn it there directly? Well, many consumers have identified this is a lot more efficient, and that's what they do, and that's why they have gas stoves. They're 3.4 times more affordable than electric stoves. Those who use gas for heating, cooking, and clothes drying on average save over $1,000 a year in their household. And when electricity goes out and you have natural disasters, natural gas is there and usually available to offer life-saving heat and to boil water. I spent about 3 hours yesterday delving into the Department of Energy's regulations and their scientific basis for what they're doing. Because I wanted to know, how can one appliance that burns gas be more efficient than another appliance that burns gas?
If you expose CH4 in the presence of oxygen, you get a certain amount of BTUs, and unless you've got some science project with a catalyst, you're going to get the same number of BTUs from both stoves. And when I dug into it, here's what they want to do. They measured efficiency by boiling a pot of water or heating up a pot of water. And they found that stoves with heavy grates or continuous grates that allow for more safety, well, they said those were less efficient because the grate heats up and less of your energy goes into your water. But people aren't cooking water, they're cooking food. And those grates, they provide more heat as the product sits, as the food sits there on the stove. The continuous grates provide safety for somebody who's not strong enough to pick up a pan, yet they're saying those are less efficient. And then in their studies, if you dig deep enough, they admit that a dogged pursuit of efficiency will result in stoves that are less healthy. Because to make it more efficient, you shorten the grates and get the pan closer to the flame. But when the flame impinges on the pan, it does all of the gas doesn't combust efficiently, and you get carbon monoxide. If all you care about is efficiency, you get more carbon monoxide. What are they doing? They're going after the high-end stoves. That's where they're going first. The ones with the heavy grates, the ones with the thick walls in the ovens that make it easier to cook good food. They're saying they're less efficient, but they're heating up water. They're not cooking food, and they're making assumptions about customers' preferences. And in the realm of electric stoves, they say, well, induction stoves are more efficient, so we'll just make everybody buy new pans because all of your pans don't work on induction stoves. So what, says the Department of Energy? This is a war on stoves. And this will be undone, the war will be undone, or stopped, halted, by the Gas Stove Protection and Freedom Act and the Save Our Gas Stoves Act. I want to finish by talking about another of the bills that's in this rule, which is to restore the separation of powers. It's pretty simple, this bill. It's 2 pages long, and it's basically a legislative repeal of Chevron deference. Now, Chevron deference may go away soon anyways, because it's based on a Supreme Court decision that said, you know what? If a regulatory agency does their best and makes a good guess about what they think the law is, well, then the court shouldn't second guess the regulatory agency. That's not the court's job. The court's job is to look at the law as was written by Congress, not to say, stretch it as far as you want, administrative branch. So the Separation of Powers Restoration Act would require the courts to look at all questions of law de novo, including interpretation of constitutional and statutory provisions. This is a wise bill. It should pass. The rule for this should pass. And I also want to note, just in closing, the American people, they don't understand why you want to give up power to the executive branch. They elected you all to come up here and represent them, to live by the laws that we write, but also to be responsible for those laws when our constituents have to live under them. It sounds absurd to the American people that we would want to give up that power that those people have entrusted to us. And whether you're into laws or the structure of government, if you just follow common sense, you know banning gas stoves isn't going to save the planet. It's going to increase prices. It's going to make it harder for low-income and middle-income families to get by if they have to buy more expensive appliances or if they have to cook their food longer. That's the result of these regulations. And all of that could be reined in with the REINS Act. And that's what we need to do. We need to pass this resolution today, get these 4 bills on the floor. We've allowed amendments. Everybody under this rules had 72 hours to read the bill. My, what a concept. Give the American people the time to read the bill as well. And we have read it. We know what these bills do. Put them on the floor. I urge a yes vote on all 4 bills, and most explicitly a yes vote on this resolution. And I yield back the balance of my time.
Kentucky is recognized.
Thank you, Madam Speaker. Our constituents didn't elect us to come here and eat fancy dinners and go from one fundraiser to the next, take lavish trips and rub elbows with important and famous people. They sent us here for one job: pass laws, or in some cases, repeal laws. Set the rules under which they will live under, and then we are accountable
every 2 years. The founders were very wise. Some people complain, but every 2 years, our constituents have a chance to replace us if the rules we've set aren't in their favor. They have no such choice with bureaucrats. Our founders didn't set this system up for bureaucrats to make the laws. Excessive regulation stifles economic growth, hurts small businesses, and raises consumer prices. In fact, much of the inflation that we see in the sectors of food and energy are due to overregulation. It's vital that Congress act to reduce our regulatory burden now, which raises consumer prices, reduces wages, and costs jobs. I think the American people watching this debate are somewhat vexed that the other side of the aisle says we need to give up more power to the executive branch when they sent us here to do something, and they wonder why we're so feckless so often. So they're probably shaking their heads. What are these other people talking about? That somebody else should make the rules that we live under. The REINS Act would require congressional approval for regulations that have a major impact on our economy of more than $100 million, or lead to a raise in consumer prices or adversely affect employment. If the REINS Act becomes law, every major regulation promulgated by the administration will come back to Congress for our approval. These regulations, they're not just regulations. These have the force of law. You can go to prison for 10 years, as we've seen with the regulation on pistol braces, just because some bureaucrat decided they wanted to pass a regulation. In fact, the jobs-crushing OSHA vaccine mandate was one of the things that we should have voted on. If you're going to do that to your constituents, vote on it. But we didn't. We let the executive branch do it. And the idea behind the REINS Act isn't novel. It's enshrined in the Constitution. Article 1, Section 1 of the U.S. Constitution says, all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a House of Representatives and a Senate. Does it say, and a bureaucracy? No, it doesn't. Does it say some legislative powers herein granted? No, it says all legislative powers herein granted are given to the Congress of the United States. Congress has delegated its authority to unaccountable federal agencies over the past decades, and our constituents are feeling that burden. Unelected bureaucrats do not have the constitutional authority to write laws, nor are they accountable to the people. They're career bureaucrats. Our Congress has this power, and ceding it to the federal agencies undermines our representative form of government. I'd like to tell the story of how the REINS Act originated. It's one of the most popular bills in Congress. It's the one bill that would do the most to restore the constitutional balance of government. It was an idea from Lloyd Rogers. Lloyd is a constituent of mine. He grew up in an orphanage where he met his wife. They were married, the girl who would later become his wife. They were married for 65 years. Lloyd served during the Korean War. Lloyd came home and he ran for county judge executive, where he served the people of Kentucky once again. And time after time, when he was trying to do the right thing for the people in Kentucky, he was frustrated by laws, but he dug into them. They weren't laws, they were rules. And he couldn't talk to his congressman to get these things fixed so that he could govern locally. So he came up with the idea of the REINS Act, gave it to the congressman who represented the district before me, and then that congressman brought it here to Congress. That is the way laws are supposed to happen, not by some bureaucrat. I want to move on to the Gas Stove Act here. Despite media gaslighting to the contrary, the Biden administration has effectively declared war on gas stoves using varying rationales. And with that, I'd like to yield to my good friend from New York 4 minutes. Mr. Speaker, reasonable minds may differ about certain policies, but under the Constitution, we should all be on the same page about who should make law. Congress should make law. Think about some of the laws that have been promulgated by the administrative branch, things that should have come to Congress. I got on an airplane a few years ago, and they said, federal law requires that you wear a mask. You know what I thought to myself? We never voted on that law. We should have voted on whether that should be a law or not. I would have voted no. It probably wouldn't have passed. And if it had, and the our constituents decide it was too onerous, they could appeal to us, not some bureaucrat. Well, there's some other examples. The vaccine mandates that cost people their jobs. These were not laws passed by Congress. These were from the executive branch. And then tonight, we've just had 2 bipartisan votes to repeal executive branch rules, one on the pistol brace and one on stoves. Bipartisan. What does that mean? That means if they had tried to bring those as laws through Congress as the founders intended, they would have failed because there would have been bipartisan opposition to that. So, we should be making the laws here. It's very simple. When unelected, unaccountable, unrecallable bureaucrats write the laws become more numerous and more onerous. We should pass the REINS Act, bring the constitutional authority back to Congress to pass legislation, and I urge adoption of the bill, and I yield back the balance of my time.
The gentleman from Kentucky is recognized.
As a father and a grandfather, my heart breaks when I see the victims of these deranged killers at schools and elsewhere. But we need serious solutions. I think it's an insult to the victims and the families to tell them that banning a piece of plastic is going to save a life. It won't. Or that telling them that putting up a sign that says gun-free zone will save a life. It won't. It will cost lives. One of my former staffers, she was married, I think, for less than a year, and her husband had a business, a karaoke business. And she had a stalker who followed them to each of their events. And she got a concealed carry license in Tennessee, and she carried her gun to protect herself from the stalker. This was Nikki, who worked for me. And one night, they set up their business in a bar, and the sign said, "No guns inside," because they served alcohol. And Nikki left her firearm to protect herself in the car. But her stalker did not leave his. He came into the bar, and he shot her husband viciously in front of her. And she has to live with that. And it's why she wants serious solutions. She knows that gun-free zones are unserious. She knows that banning pieces of plastic are not serious. She knows that children deserve the protection that we have here. We all know, if you're willing to look at the data, in every school that has allowed qualified teachers and staff to carry a firearm, there has never been a school shooting. It's a fact. And we need to work on serious solutions, not unserious solutions like banning a piece of plastic. Now on to the stove ban, which is also unserious, but it's going to cost consumers. It's going to make the products less safe, not more safe. It's going to make them less available. It's not about the safety or efficiency or consumer benefit. It's about banning fossil fuels, and that's why this administration has declared a war on gas stoves. 2 of the bills in this package would repeal those rules from this administration. Natural gas, when it's used in appliances, is 3.4 times more affordable than electricity. Now, why is that? Well, let's think about where that electricity comes from. A natural gas plant can burn electricity, spin a turbine, create electricity at maybe 50% efficiency, then put it on wires that are hundreds of miles long to go to a household, and those wires may be 70% efficient, 80%. Then when it gets to the household, what do you do with that energy that came from the natural gas that's now electricity? You turn it back into heat if you have an electric stove, which is how this administration would want you to live. But guess what? That's less than half as efficient. It costs 3.4 times more to do it that way than to create electricity with natural gas and then use the electricity at your house than if you just brought the natural gas to the household. In fact, consumers who use natural gas in their house save over $1,000 a year. This is a war on the middle class and the poor, the war on gas stoves, since it's a war on affordable heating and cooking. When the electricity goes out in natural disasters, whose stove works? The ones who have gas stoves. Who can boil water to drink when the water's unsafe because of a natural disaster? Those who have gas stoves. This administration should quit gaslighting consumers by telling them they're acting in their best interests. The Federal Interagency Committee on Indoor Air Quality has never identified gas stoves as contributing to asthma or respiratory illness. And the Consumer Product Safety Commission and the Environmental Protection Agency have never identified gas stoves as a significant contributor to adverse air quality or as a health hazard. So why are they doing this? It's a war on gas stoves. And these two bills would seek to reverse that. And it's just common sense. In fact, the other side of the aisle said these are messaging bills. Guess what? Some Democrats like the message because they voted for these bills in the Energy and Commerce Committee. Must be a great message. Must be a message the American people want to hear. Must be a message that they like to hear because they know if we had the Senate and the White House, this kind of ridiculousness would not go on. And that's why it's important to pass these two bills to protect our gas stoves. And I reserve the balance of my time.
For what purpose does the gentleman from Kentucky seek recognition?
For the purpose of debate only, I yield
The gentleman is recognized for 1 hour.
For the purpose of debate only, I yield the customary 30 minutes to the gentleman from Massachusetts, Mr. McGovern, pending which I yield myself such time as I may consume. During consideration of this resolution, all time yielded is for the purpose of debate only. Mr. Speaker, I ask unanimous consent that all members have 5 legislative days to revise and extend their remarks.
Without objection.
House Resolution 495 provides for a structured rule for consideration of H.R. 277, the regulations from the Executive in Need of Scrutiny Act of 2023, and provides 1 hour of debate equally divided and controlled by the chair and ranking member of the Committee on Judiciary. House Resolution 495 further provides for a structured rule for consideration of H.R. 288, the Separation of Powers Restoration Act of 2023. This and it also provides 1 hour of debate equally divided and controlled by the chair and ranking member of the Committee on Judiciary. House Resolution 495 further provides for a structured rule for the consideration of H.R. 1615, the Gas Stove Protection and Freedom Act, and provides 1 hour of debate, equally divided and controlled by the chair and ranking member of the Committee on Energy and Commerce. This resolution further provides for a structured rule for the consideration of H.R. 1640 and provides 1 hour debate, equally divided and controlled by the chair and ranking member of the Committee on Energy and Commerce. Furthermore, House Resolution 495 provides for a closed rule for consideration of House Joint Resolution 44 and provides 1 hour of debate equally divided and controlled by the chair and ranking member of the Committee on Judiciary. These are 5 bills that may seem unrelated, but they're very related, and they have to do with the power of Congress and the fact that our power has atrophied considerably since the beginning of this country. In fact, we're almost a vestigial organ of this republic at this point. Our power, we've ceded so much power to the executive branch, and that's how all of these bills are related. 3 of the bills seek to repeal laws or regulations that the administrative branch is unconstitutionally, I would argue, promulgating. And 2 of these bills get at the heart of the matter, the problem that we have. And one of them specifically is the REINS Act, which is very important. This would rein in our power to legislate. I don't think our founders would recognize our form of government at this point. They never intended for the administrators to be the lawmakers. Yet here we are. So the Regulation in Need of Scrutiny Act would take every major regulation that's suggested, and I say suggested, by the administration back to Congress, where there would have to be a positive vote of the House and the Senate in order for that to go to the president, and then with his signature become law, as all laws should do. And then the other bill in this package that seeks to address the sort of chronic problem that we have here in Congress is the Separation of Powers Restoration Act. It's basically a repeal of a horrible Supreme Court precedent called Chevron deference that says that basically any way the administration wants to construe one of our laws, they can get away with it, and the Supreme Court will give deference to the interpretation, no matter how far afield from the original interpretation of the law there was given from Congress. Finally, the 3 bills that deal with the 3 bills today that deal with individual regulations. Two of them deal with gas stoves. This administration has a war on gas stoves. Depending on which person from the administration you listen to, the rule that's being promulgated by the Consumer Safety Product Group and also by the Department of Energy, there are two rules here, they would ban between 95 to 50% of the gas stoves on the market for arbitrary reasons. And it's not clear that there would be any consumer benefit from banning these. In fact, consumers would suffer from this ban. These are the types of rules that we need the REINS Act for. They would have significant impact on our economy, and that's why they should be here in front of Congress, and that's why we're seeking to countermand them here today. And then finally, and I think this is the most important rule that we are countermanding in legislation this week, and that is the pistol brace rule from the ATF. You know, we're not talking about an interpretation of a law where the EPA says, you know, we think we should allow this much sulfur dioxide instead of that amount of sulfur dioxide and create a civil infraction where corporations could be sued or punished. We're talking about criminal penalties. The ATF has twisted existing statute, a law that was passed by Congress in 1934. Now they've magically reinterpreted it to create tens of millions of felons beginning on June 1st. So we've got a bad situation in this country right now where millions of people have been turned into felons, law-abiding individuals who are following the rules that were set forth by the ATF. And that's why urgent action is required on the pistol brace rule repeal here today. And that's House Joint Resolution 44. With that, I reserve the balance of my time.
Gentleman reserves. The gentleman from Massachusetts is recognized.
Mr. Speaker, I want to thank 2 minutes to my very good friend from Kentucky and fellow member of the Rules Committee, Mr. Massie.
The gentleman from Kentucky, Mr. Massie, is recognized for 2 minutes.
Mr. Speaker, as the only still serving co-author and co-sponsor of the motion to vacate Speaker Boehner, I can tell you this motion to vacate is a terrible idea. As the only member who's serving here who took every chance to vote against Speaker Boehner and to vote against Speaker Ryan, I can tell you that this chamber has been run better, more conservatively, and more transparently under Mr. McCarthy than any other speaker that I have served under. As a member of the Rules Committee, one of three conservatives who were placed there out of trust, the Speaker gave us a blocking position by putting 3 of us on there to keep an eye on the Rules Committee to make sure the process was fair and even. I can tell you it's been fair and even. None of us are voting against the Speaker today. Regular order is at odds with predetermined outcomes. Yet the Speaker is being accused of not holding to regular order and predetermined outcomes at the same time. It is not possible. You cannot be for both at the same time. I was a party to the January agreement, and I can tell you that there were promises in there, but there was never a promise for an outcome. There was never a promise that you could force Joe Biden to sign something. There was only the promise that we would try, and try we have. We have tried in the Rules Committee. We have tried on the floor. We've been trying this since the summer, and there's enough blame to go around for why we don't have 12 bills, but part of it was a relitigation of the debt limit deal. By the way, there was no promise on the debt limit deal, no conditions on that in January, 0 whatsoever. I was in the room for that. So the 12 bills were delayed over what? $100 billion. That's a lot of money. But it's nothing compared to the $2 trillion that I came here to object to when Speaker Pelosi and President Trump pushed that bill through. We've had over 500 amendments. Listen, this is a referendum on this institution. We have tried regular order. Speaker McCarthy has tried regular order. If regular order fails today, if you vacate the Speaker, nobody is going to try it again.
Gentleman's time has expired.
This institution will fail. Please do not vacate the Speaker.
From Kentucky, Mr. Massie, and a member opposed. Each will control 5 minutes. The chair recognizes the gentleman from Kentucky.
Mr. Chair, I rise in support of my amendment, which states none of the funds made available by this act may be used to conduct a competition analysis when evaluating mergers. Beginning in January 1 of 1989, Congress vested primary authority to review airline mergers with the U.S. Department of Justice. Since that time, the Department of Transportation has deferred to DOJ to determine whether a merger between U.S. airlines should be challenged on competition grounds. The Department of Transportation's General Counsel under President Obama described the DOT's role in airline mergers as follows. Quote, with respect to DOT's competition and public interest review authorities, DOT's practice has been to use its expertise with respect to the airline industry to provide the department's views and otherwise assist the DOJ in DOJ's analysis of airline mergers or acquisitions, end quote. The Department of Justice recently challenged an airline merger. Now, this amendment doesn't have anything to do with that court case. In fact, it's well within DOJ's rights and authority to challenge mergers. But what concerns me is that the DOT Secretary Pete Buttigieg expressed publicly that his department, quote, has generally not gotten involved in these mergers cases, but that's changing today, end quote. Between 2009 and 2016, under the Obama administration, there were 9 successful airline mergers. In fact, in over 30 years, the DOT has not prevented the transfer of operating certificates for any airline merger. This begs the question, why now? I urge adoption of this amendment, and I reserve the balance of my time.
The gentleman reserves. For what purpose does the gentleman from Illinois seek recognition?
Mr. Chair, I claim time in opposition.
The gentleman is recognized.
Let me begin by saying that sponsor of this amendment, I believe, is on the T&I committee, which is the authorizing, has jurisdiction over aviation and rail. This is an amendment which would be better off being moved forward as an authorizing proposal rather than going forward as an appropriation amendment. But this amendment makes it plain as day that the Republicans are happy to put the interest of big corporations ahead of protecting the American people from corporate greed that increases costs, reduces quality of service, and limits options. Specifically, it prohibits any funds for conducting a competitive analysis of mergers, which raises concerning implications for both airlines and rail. The Department of Transportation is required by law to certify that Congress that an approved airline merger is in the public interest and provide an analysis of the effects of the merger on competition in the domestic airline industry. Congress itself has set forth in law a list of factors that are considered in the public interest, which includes several related to competition. Yet this amendment would prohibit the Department of Transportation from complying with that requirement and from even conducting an analysis or considering factors Congress has specifically identified as important, shirking all responsibility to the public interest. At the same time, this broad amendment would implicate all THUD agencies, also impacting competition in the rail industry and our understanding of competition in the housing market. The Surface Transportation Board has authority over railroad corporate mergers and acquisitions, and similarly may approve such mergers only when it finds them to be in the public interest. This requires evidence that the proposed merger will affirmatively enhance competition, efficiency, and quality of service. This amendment ties the hand of the agency with exclusive merger jurisdiction involving railroads, even as the number of Class I railroads has fallen from 40 to 6 since 1980. Further, the Department of Housing and Urban Development would be prevented from conducting any competition-related analysis to inform our understanding of rental markets, even as Americans face rising rents and corporate landlords are caught price fixing. Competition is critical to protecting consumers from corporate greed and fostering a flourishing market economy, something we should all fight for. I urge my colleagues on both sides of the aisle to reject this misguided amendment, and I reserve.
The gentleman reserves. The gentleman from Kentucky is recognized.
At this point, I would like to yield 2 minutes to my friend across the aisle, the ranking member of the Judiciary Subcommittee on the Administrative State Regulatory Reform and Antitrust, Mr. Correa from California.
The gentleman is recognized.
Thank you, Mr. Speaker. Mr. Chairman, I rise today in support of Mr. Massie's amendment, which prohibits the Department of Transportation from expediting funds to conduct competitive analysis of mergers. In 1989, Congress transferred authority to review airline mergers to the Department of Justice. 35 years of DOT policy is clear. DOJ has the leading role in reviewing proposed airline mergers. And given this statutory authority to enforce the antitrust laws, this is consistent with Congress's authority determining that deregulated airline industry should generally be subject to the same applications of antitrust laws as other unregulated industries. I must say that as ranking member of the Antitrust Subcommittee, I am committed to protecting consumers, competition, and innovation. But before the DOT moves ahead with this new unprecedented approach, we must take time to evaluate its merits, and this amendment does exactly that. Give us time to see what's going on. I urge my colleagues to support this amendment.
The gentleman from Kentucky reserves. Gentleman from Illinois.
Mr. Chairman, I reserve.
Gentleman reserves. Gentleman from Kentucky.
May I inquire as to how much time I have remaining?
Gentleman has 1.5 minutes remaining.
At this point, I'd like to yield 1 minute to my colleague, Mr. Rutherford from Florida.
The gentleman is recognized.
Thank you, gentlemen, for yielding. And I rise in support of this amendment. And I really want to reiterate the fact that the point that was just made, that this is such a break from the norm in evaluation of these antitrust analysis going forward. DOJ's had that responsibility. I particularly want to thank the gentleman for the really staying on top of this. This is clearly an overreach by the Biden administration, and I want to thank you for that, and I yield back.
Reserve.
The gentleman from Kentucky reserves. Gentleman from Illinois is recognized.
Mr. Chairman, I'm not sure how to phrase this, but I'd like to ask the sponsor of this amendment through the chair a question. I believe he referred to the Secretary of Transportation's name. I wasn't sure I heard that correctly. If you could ask the sponsor if he would repeat how he referred to the Secretary of Transportation, because the acoustics aren't always great here. I want to make sure I got it right.
Is the gentleman yielding?
Yes. Well, I would reserve. I'd like to ask the question through the chair.
The gentleman reserves.
I reserve.
Gentleman from Kentucky is recognized.
Is the gentleman prepared to close?
I'm prepared to close. I'd still like to make sure I heard what I thought I heard correctly.
I reserve.
Gentleman reserves.
The gentleman reserves. The gentleman from Illinois is recognized and has the right to close.
Gentleman from Illinois is recognized and has the right to close.
Okay, Mr. Chairman. I assume that's the answer is that the sponsor doesn't want to repeat what he may have said. I just didn't hear it, and at this point, I'm prepared to close, and I yield back.
Gentleman yields back. Gentleman from Kentucky.
Well, as a member of the Transportation Committee, I had the honor to question Secretary Buttigieg on whether he had this authority and what metrics he would use to exercise this authority. And it was obvious that they don't have any experience in the DOT to review these mergers because they haven't done it. And so it is for that reason that I urge adoption of this amendment. We don't need redundancy among the departments, and we need an all-of-government approach, and that's what this amendment seeks to do, and I urge adoption of this bipartisan amendment.
The question is on the amendment offered by the gentleman from Kentucky. Those in favor say aye. Aye. Those opposed say no. In the opinion of the chair, the ayes have it. The amendment is agreed to.
Mr. Chair, I demand a recorded vote.
Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from Kentucky will be postponed. It is now in order to consider Amendment Number 60, printed in Part B of House Report 118-261. For what purpose does the gentleman from Kentucky seek recognition? In Part B of House Report 118-261. For what purpose does the gentleman from Kentucky seek recognition?
Mr. Chair, I have an amendment at the desk.
The clerk will designate the amendment.
Amendment number 60, printed in Part B of House Report number 118-261, offered by Mr. Massie of Kentucky.
Pursuant to House Resolution 838, the gentleman from Kentucky, Mr. Massie, and a member opposed, each will control 5 minutes. The chair recognizes the gentleman from Kentucky.
Mr. Chair, I rise in support of my amendment, which states none of the funds made available by this act may be used to implement Section 24220 of the Infrastructure Investment and Jobs Act. My amendment is simple. It will defund the federal mandate that requires all new vehicles after 2026 be equipped with a kill switch that can disable a vehicle if the vehicle has monitored the driver's performance and that the vehicle determines that the driver is not performing well. It's so incredible that I have to offer this amendment. It almost sounds like the domain of science fiction, dystopian science fiction, that the federal government would put a kill switch in vehicles that would be the judge, the jury, and the executioner on such a fundamental right as the right to travel freely. But here we are. It is federal law that this is mandated, and so I am offering this amendment to defund this mandate. And with that, I reserve the balance of my time.
Gentleman reserves. For what purpose does the gentleman from Illinois seek recognition?
Mr. Chairman, I claim time in opposition.
The gentleman is recognized.
Mr. Chairman, I yield 1 minute to the gentleman from Florida, the ranking member of the Military Construction and Veterans Affairs Subcommittee, Ms. Wasserman Schultz.
The gentlewoman is recognized.
I thank the gentleman for yielding. I actually need 2 minutes, if that's possible, Mr. Chairman.
We'll do 2 minutes, Mr. Chairman.
Thank you.
The gentlewoman is recognized.
Thank you very much. Lobbying in mid-sentence. I rise in opposition to this amendment. Let me be clear. The act that the gentleman is trying to defund does not require auto manufacturers to install kill switches. It does not do that. Passive drunk driving technology is a vital tool in safeguarding our loved ones and other innocent people on our roads. This new technology offers a lifeline of hope to not only save lives, but to prevent the lifelong emotional toll and gargantuan costs these accidents inflict on families. Deadly drunk driving accidents can echo across generations, but we can seize this opportunity to stop such tragedies. Between 2019 and 2021, Florida saw a 31% increase in drunk driving crashes. In Mr. Massie's home state of Kentucky, 190 people were killed in drunk driving crashes in 2021 alone. That was a 26% increase. When we saw these grim statistics, we acted in a bipartisan fashion in Congress. And how often do we see that? Both Republicans and Democrats supported the HALT Act to require auto manufacturers to make this passive technology standard in new vehicles. The sponsor of this misguided amendment will tell you that he worries about privacy concerns. We heard the same inane calls with seatbelt requirements. But you don't have a right to engage in potentially fatal behavior that we know poses a major health threat to public safety. Passive drunk driving technology is pro-police. This anti-drunk driving technology lightens the load on police officers, allowing them to focus on more pressing safety concerns. The importance of this technology goes far beyond statistics. It's about saving lives, preventing heartbreak, and making our roads safer. It's a passionate call to action to prevent alcohol-impaired driving from shattering the lives of those we hold dear. This amendment, I understand, was dubbed the Kill Switch Amendment, and it does not require a kill switch. It simply requires passive technology to help us prevent drunk driving. In the name of the 406 people that were killed by a drunk driver in my own state of Florida last year alone, I urge my colleagues to vote no on this amendment. Let's take steps to reduce deaths due to drunk driving, not increase them. Thank you. I yield back the balance of my time.
Gentleman reserves. Gentleman from Kentucky is recognized.
Drunk driving is a serious problem. That's why 31 states already have a law to implement interlock ignition technology, where if you've been convicted of a DUI, that you have to pass this test in order to operate your vehicle. But this federal law that I seek to defund goes far beyond that, and I regret that I have to spend some of my time reading the law to the other side of the aisle, but I will do that. This law that was passed in a 1,000-page bill 2 years ago requires that automobiles can passively monitor the performance of a driver, not the blood alcohol content, but the performance of a driver of a motor vehicle to accurately identify whether that driver may be impaired, not drunk, it says impaired, and prevent or limit motor vehicle operation. That's a kill switch. Now, the question is, how much time do you have once your dashboard tells you that it doesn't approve of your driving? What if you're a single mother and you're out in bad weather and you're trying to avoid some obstacles, ice perhaps, and you've swerved 3 times, and your dashboard says, swerve 1 more time, and you're going to be put over to the side of the road, that you'll have 100 yards to park this vehicle in the middle of nowhere with your children in the back seat. This isn't some fantastical scenario. This is what will happen if this is implemented. And this is the law. I have read it to you here. Now, you maybe should have read it 2 years ago when you all voted for it on that side of the aisle, but it wasn't a bill that was 1,039 pages long. So I can understand how you don't know what the law has in it, but I've read it to you. And with that, I reserve the balance of my time.
Member is reminded to direct his remarks to the chair. Gentleman from Illinois is recognized.
Thank you, Mr. Chair. I yield 1 minute to the gentlewoman from Illinois, Ms. Schakowsky.
The gentlewoman is recognized.
Thank you, Mr. Chairman. More than 10,000 people die every year from drunk driving crashes. Drunk drivers are 7 times more likely to be involved in a fatal crash than a sober person. So you would think that the Republicans would want to do something about it. Democrats have done something about it and said that NHTSA now will have drunk driver prevention technology. You know, this technology has the potential of saving thousands of lives. And I don't see that you're agreeing that we should be saving those lives, and I would say we should all vote against the Drunk Driver Protection Act. And I yield back.
Gentleman reserves his time. Gentleman from Kentucky is recognized.
May I inquire as to how much time I have remaining?
And has 2 minutes remaining.
Well, we actually don't know how this technology is going to work, and they don't know over at the DOT either, because we've sent a letter to them that they haven't responded to yet, asking them, will this have cameras inside the car? Will it monitor your eyes to see if you're focused on the road? Will it have cameras on the outside of the car? How will it know what your performance is relative to the road that you're driving on if it doesn't, in fact, know which road you're driving on? Will it need to know where you are when you are driving? If so, who has access to this data? Who has access to those cameras? Will the Fourth Amendment be followed? Will you require a warrant for your insurance company to access this data? Will you require a warrant for the government to access this data? Once your car's been disabled and now you're on the side of the road with your children in it for reasons you don't understand, how long until the police show up? Or what if you truly are disabled and you're over to the side of the road? Does anybody show up? How long do you have to get out of the vehicle? Who decides when your vehicle kill switch is disabled and you get to drive again? Who's going to adjudicate that on the side of the road? What if it's rush hour traffic? What if you know you've already got points against you according to your dashboard and it's monitored your performance, and now there's somebody's pet in the road? Do you swerve to miss it and get your car disabled? What if there's an emergency vehicle approaching from behind you and you know the right thing is to swerve off the road and let that vehicle pass? What after you've done that 3 times and now your car says do it 1 more time and we're going to leave you on the side of the road? This is in the law. This will become law in 2026, every vehicle manufactured after that. And it's not about drunk driving. If it were, it would just be about blood alcohol content. This law has far more than that in it. It violates the Fourth Amendment. It violates so many amendments. It violates things that are so fundamental to our rights. They're not even in the Constitution, like the right to travel. And so I urge support of this amendment. It will defund the law that was passed 2 years ago that the other side of the aisle doesn't even know exists. And I yield back.
Gentleman from Illinois is recognized.
Mr. Chairman, I yield 1.5 minutes to the gentlewoman from Michigan, Mrs. Dingle.
The gentlewoman is recognized.
Thank you, Mr. Speaker. I rise in strong opposition to this amendment. This amendment seeks to prohibit funding for the implementation of a bill known as the Honoring the Abbas Family Legacy to Terminate Halt Drunk Driving Act. I wrote it. I'm the sponsor. The Halt Drunk Driving Act honors the Abbas family from Michigan who were tragically killed in a car accident by a drunk driver. It requires NHTSA to do a rulemaking to create rules for impaired driving prevention technology and new vehicles to stop these tragedies from continuing to occur. 37 alcohol-impaired driving deaths happen every day, equivalent to a death every 39 minutes. Studies show that the HALT Act could save over 10,000 lives annually, and our constituents agree. We need to stop drunk driving by making impairment prevention technology standard in new vehicles, and if the technology exists to prevent drunk driving, why wouldn't we consider it? Let me close by saying this amendment and the sponsor mischaracterized what the HALT Act is. It does not mandate kill switches or allow data collection that invades vehicle occupants' privacy. I protect data privacy in vehicles probably more than the sponsor of this does. It's ridiculous, and it doesn't monitor how you drive. This amendment is an insult to every American who's been hurt or lost loved ones to drunk driving, including the Abbas family. Let's honor the memory of those affected by drunk driving. Thank you, and I yield back.
Gentleman from Illinois.
Reserve.
Has the remaining time left.
How much time do I have left, Mr. Chairman?
Gentleman has 30 seconds remaining.
Mr. Chairman, let me close by saying this. I gave the gentleman from Kentucky an opportunity to clarify his pronunciation of Secretary Buttigieg's name. I have the belief that he purposely mispronounced it to disrespect him. He wants to correct that by correctly pronouncing it. I would yield the time to him. As they say, it speaks for itself, Mr. Chairman. I yield back.
The question is on the amendment offered by the gentleman from Kentucky. Those in favor say aye. Aye. Those opposed say no. No. In the opinion of the chair, the ayes have it. The amendment is agreed to.
Mr. Chairman, vote.
864, the gentleman from Kentucky, Mr. Massie, and a member opposed. Each will control 5 minutes. The chair recognizes the gentleman from Kentucky.
Madam Chair, I rise in support of my amendment, which essentially prohibits funds from being used or being made available to conduct or support gain-of-function research. Section 533 of the underlying bill says that none of the funds in the bill can be used for gain-of-function research in China or Cuba or North Korea or Russia. The problem is that it doesn't prohibit this dangerous type of research anywhere else in the world. Why should we be funding it in France or Great Britain? In fact, why should we be funding it here? I will argue later that we shouldn't, that the risks far outweigh the benefits, and that we should have learned our lesson. And with that, I reserve the balance of my time.
The gentleman reserves. Does any member claim time in opposition? Seeing none, hearing none, the gentleman is recognized.
Madam Chair, at this point, I'd like to yield a minute and a half to my colleague, Ms. Miller-Meeks.
The gentlewoman from Iowa is recognized.
Thank you, Madam Chair. I rise in support of the amendment number 116 with Mr. Massie to ban the funding of gain-of-function research. For decades, scientists have been warning that gain-of-function research with potential pandemic pathogens could cause an outbreak. From 2014 to 2017, we had paused funding for gain-of-function research after a series of lab accidents and due to fear of a lab-caused pandemic. However, Dr. Fauci and others recommended that the prohibition be removed, and unfortunately, our worst fears came true. Among many others, the FBI, Department of Energy, and a majority of Americans now believe that a laboratory in Wuhan, China, that was conducting NIH-funded gain-of-function research on bat coronaviruses caused the COVID-19 pandemic. This was a wake-up call. Last month, during a select subcommittee on the virus pandemic hearing, Dr. Gerald Parker, former commander of the United States Army Medical Research Institute of Infectious Diseases and the current head of the federal committee that oversees gain-of-function and biosecurity, testified to Congress that gain-of-function research with potential pandemic pathogens has not contributed significantly to biodefense and that its benefits have been exaggerated. Dr. Parker also stated that there are safer alternatives available. Fortunately, last year, Congress passed and enacted common sense language in the labor HHS bill to prohibit gain-of-function research with pathogens in hostile foreign nations, including Russia and China. We must now expand that effort and prohibit taxpayer funding for this dangerous research on U.S. soil and other nations where oversight is lacking. Prohibiting taxpayer funding of dangerous gain-of-function research with potential pandemic pathogens is a common-sense solution to protect public health and national security.
Gentlewoman's time has expired.
I urge my colleagues to vote yes on this amendment, and I yield back.
Gentleman from Kentucky is recognized.
Madam Chair, I think it would be useful at this point to define gain-of-function research. And I will use the written testimony of Richard Ebright, Board of Governors Professor of Chemistry and Chemical Biology at Rutgers University and Laboratory Director of Waxman Institute of Microbiology. In his testimony in a Senate hearing, he said that gain-of-function research is defined as research activities reasonably anticipated to increase a potential pandemic pathogen's transmissibility, pathogenesis, ability to overcome immune response, or ability to overcome a vaccine or drug. Now, why would you want to do this? Why would you want to do gain-of-function research? It's a seductive idea that you could take one of hundreds of thousands of viruses that exist in the animal kingdom outside of humans and try to predict, poke and prod on the virus, encourage it to be transmissible among humans so that you could then predict the next virus that might come into existence among humans and then come up with a vaccine for it. But statistically, there's no way you're going to predict what the next natural virus is going to be. What you will do, though, in the process of this research is create a cookbook, a blueprint for the next pandemic. So the danger in this research, part of the danger lies in the fact that you are uncovering secrets that will then be published that can be used to create a pandemic of existential proportions. It creates new health threats that through 10,000 years of evolution may never come into existence, but in 10 days of research could come into existence in a lab. Threats that don't exist in nature. So why are we still doing this research right now? Well, in 2014, this research was put on pause from 2014 to 2017. Wisely, I would say. But then the pause was suspended in 2018. By the way, the projects that were paused did not include the projects at the Wuhan Institute of Virology, unfortunately. But then when the pause was removed, this research began again in earnest. Again, creating tremendous risk for the human race. Why would we do this to ourselves? We shouldn't be doing this to ourselves, and we shouldn't be doing it with taxpayer dollars. There is no practical application of this outside of the curiosity of a government lab. This research will not continue in private labs because it's just not profitable. So we should stop it here. And with that, I urge adoption of the amendment. I think it's common sense, and let's protect America by not funding this research. And I yield back.
Gentleman yields. The question is on the amendment offered by a gentleman from Kentucky. Those in favor say aye. Those opposed say no. In the opinion of the